Contract law, termination of offer. What do we need to know? Legal terms that you need to know about revoking an offer and how to revoke an offer. Time lapse and the lapse of duration of an offer, rejection and counter offer. That's what we're covering, so let's get on with it. Rejection is an offer that is not accepted. You reject it. Would you like to buy my hat for $10? No, thank you. Oh, okay. I'm rejected. Revoke, the offeror. Would you like to buy my hat? May withdraw an offer before it's accepted. No, sorry, somebody else has just offered me some more money for it, so sorry, I'm going to sell it to somebody else. Termination. This is when an offer is ended for some reason, and there might be a number of reasons why you might terminate an offer. Counter offer. Would you like to buy my hat for $10? And you counter offer and say $8. That means the first offer is terminated. The material subject of the offer changes. Changes as in I'm selling my hat, but my hat's got a hole in it and it's damaged. You didn't realize that. The main object of the agreement is materially different or changed or altered in some way, and therefore that offer can be terminated. As you can already see, there are different ways the offer can be terminated, and in the examples just now, by the offeror, the person making the offer says it's but normally this has to be done before the offer is accepted. The offeree, on the other hand, might terminate the original offer by making a counter offer, perhaps. And there may be other circumstances like the death of somebody in the agreement, etc., or a material change to the subject of the offer. So normally, an offer can be revoked, terminated, ended, withdrawn at any time before it has been accepted, unless it is a firm offer with a time limit stated. Rejection happens when the offeree clearly communicates their intentions to reject the offer to the offeror. So, no, thank you very much. I don't want your hat. This type of rejection is effective when the offeree learns of the rejection. Now, there can be a bit of a delay there depending on the method of communication for the rejection. Perhaps in your agreement that the termination, rejection, end of the offer or non-acceptance has to be done in a certain way. Perhaps you have to accept the offer in writing only rather than by text message or something like that. The type of rejection is effective when the offeree learns of the rejection. Sometimes there is a delay between the acceptance and rejection process. The offeree asking for more information is not a rejection or a counter offer, as the material subject of the agreement remains the same. So you're simply asking for more information. You're not saying yes to the offer, you're not saying no to it, but you are inquiring as to more information that might help you make a decision. That doesn't mean that the offer has ended or that you have decided to reject that offer. You're simply searching for more information. Perfectly normal. If the offeror wishes to withdraw their offer, they must communicate it to the offeree before it has been accepted. So at any point, I make an offer for you to buy my hat, and I can end that offer at any point before you say, yep, I agree to that, $10, it's mine. As long as you haven't done that, then it's okay. I can say, no, I've changed my mind. I don't want to sell my hat. The offer ends when it has been communicated to the other party, and then once that's been communicated, then it's no longer valid or legally enforceable. So we don't have part of our agreement there existing anymore. The offer is there, but there is no opportunity now to make an acceptance because I've withdrawn the offer. Now, an offer may be terminated through a lapse of time, and it depends on the product, it depends on the service, depends on what the agreement is, what is the material subject of your contractual agreement. Offerees normally have a reasonable period of time to respond once they learn of an offer. And what is reasonable, of course, comes up as usual. What's reasonable? What is a reasonable period of time? So it might be reasonable to expect a person to accept an offer for 1 ton of tomatoes reasonably quickly, because tomatoes go bad. You can't say, I'll think about it, and then come back in a month's time and say, yeah, do you know what? I want those tomatoes now. Thank you very much. Too late. The tomatoes have been sold on. And you can't say that it was unreasonable and I should have held those tomatoes for you. Of course not. That would make no sense. By the time frame can vary based on the contract subject matter as well as other prior deals. What is the standard norm? And have you dealt with this before, and what were the procedures then? So what is reasonably expected within that trade or that product range or whatever to be a reasonable time to get back with acceptance of an offer?